So thank you very much for the invitation to speak to you from across the Tasman about recent developments in Australia. In the brief time that I have, I want to talk to you a little bit about recent developments in proportionality analysis in the constitutional sphere. So the Hansen type line of cases, which you will all be extremely familiar with, were cases that were grappled with by the High Court of Australia several years ago in a case by the name of Momcilovic and the Queen, a case you may again be familiar with. That case arose in the context of the Victorian Charter of Rights and Responsibilities and the question of how and when courts in Australia, particularly Victorian courts, should go about the process of determining the justifiability of limitations on rights. In Momcilovic, the High Court split 3-3, with Justice Hayden issuing an opinion that doesn't count for the purposes of resolving this question because he would have invalidated the entire statutory scheme. They split 3-3, 3 judges in favour of the Hansen approach of determining justifiability of limitations on rights before going to the question of reading down or any kind of remedy under a Bill of Rights, and 3 judges would have preferred an approach that read statutes down or engaged the question of interpretation before reaching questions of justification. Now, those 3 judges were very clear that they thought judgments about proportionality were not suitable for courts and should be assumed to be part of the legislative process. Now, Momcilovic was decided in 2011 and indicated real resistance from members of the High Court toward what is an increasingly common technique, which is familiar to those of you in New Zealand, in the audience, and broadly across the world, which is the use of proportionality doctrine. But now fast forward to more recent cases in Australia, cases like McCloy and Brown, which were decided in the last couple of years, and you have seen a distinctly new embrace of proportionality analysis. McCloy was a case about bans on donations, political donations by property developers. And in the ultimate analysis, the High Court by majority upheld those provisions. But in doing so, 4 members of the court made an important change in the law in Australia. Some of you will be familiar with the implied freedom of political communication, which the High Court has said is implied or incidental to the system of constitutionally prescribed system of representative and responsible government. And when the court applies the implied freedom of political communication, it asks 2 questions. So that first question is the implied freedom engaged or effectively burdened? And the second question the court has said is whether any limitations on that right are reasonably appropriate and adapted. Now, that's a very distinctly Australian phrase that has appeared again and again in the constitutional area in Australia. And in McCloy, 4 judges turned it into a more globally recognisable test. They used the words, is it reasonably proportionate to the achievement of a legitimate purpose in a manner compatible with the constitutionally prescribed system of representative and responsible government. Now, toward the end of last year, in a case called Brown against Tasmania, the High Court was again asked to address the implied freedom of political communication and to give us more guidance about its current views on proportionality. Brown was a case about prohibitions in Tasmania on access to certain business premises or business access areas which were defined in the Tasmanian law to include certain forestry areas. These laws were adopted against the backdrop of general trespass and other kinds of laws that did protect forestry areas, but that had a particular view to preventing protest against logging that disrupted that kind of activity. And by 5-2, the High Court struck down this law as an impermissible burden on the implied freedom of political communication, given that it was very clear that some of what the law targeted was political and it was vague as to circumscribing the limits of the prohibition. The key finding for our purposes was that 4 judges explicitly endorsed proportionality as an appropriate and useful way of applying the second limb of the Longy test. And so that once again, by a narrow majority, the High Court of Australia endorsed proportionality. or an approach that says that suitability, necessity and adequacy in the balance are the way in which we apply notions of reasonable necessity or reasonably appropriate and adapted requirements under the second limb of Longy in Australia. So I think Brown, a very recent case, shows us that proportionality is, by narrow majority, a part of Australian constitutional law that has changed and that change is here to stay, at least for the foreseeable future, but that the limits of it in other areas of doctrine or other cases will still be open for debate because the court has split so narrowly on this question. I've circulated a short note about these cases and some further reading. I hope that this overview is useful. I think the most interesting thing for New Zealand is in this line of cases a trend toward New Zealand, a Hansen-style approach, but with a very slim majority and it being clear that the High Court is going to still have to resolve many of the questions of when and how proportionality applies in different areas of constitutional discourse in Australia.